Good morning or happy lunchtime or happy afternoon. Welcome to our Thomson Coburn CLE webinar entitled Help from the Dark Side, a Litigator's Perspective on Commercial Real Estate Issues, Part 1. There might be more to come. We hope that to have at least one or more other parts with respect to these types of issues. And please, if you have topics to discuss, please email them to me so that we can include them in the next presentation. Today, I will discuss three different issues that arise within the context of commercial real estate: alternative dispute resolution, also called ADR, liquidated damages, and letters of intent. We want to give you an overview of these issues so you can make an informed decision when you are negotiating your transaction documents or if you are faced with potential or actual litigation. We would like this webinar to be interactive, so please send us your questions or comments by using that chat button at the top of your screen. This program is CLE certified, and CLE certificates will be sent to you once we verify attendance. If you are seeking CLE for this webinar, please verify your attendance. During the webinar, 3 code words will appear. When the codes appear, please write them down, as you will need to provide them in the verification form included in the login instructions sent to you. All CLE questions should go to cle-tc@thomsoncoburn.com. You must log in with the same email address you used to register for the webinar. This login is proof of attendance and supports our awarding you CLE. If you need to leave the webinar, you should log out, and then when you return, log back in. The webinar is 1 hour long, but if questions continue to come in after, I will remain online for an additional 5 to 10 minutes in order to continue to answer questions. Of course, you can always email me or give me a call after the webinar is over, and we can discuss other issues as well. The webinar will be recorded and will be available within about 10 days at www.thomsoncoburn.com/TCLE. An electronic survey form will be sent to you shortly after we conclude today. We would very much appreciate you taking the time to fill in the form and return it to us. With respect to the first topic, ADR, the methods used to remedy breaches of the deal documents are not boilerplate, as some people assume, but they're very important. And of course, negotiating the dispute resolution provisions during the negotiations is much better when everyone is happy with each other and easier than trying to figure it out after everyone gets upset with each other and a dispute is already brewing. We're going to talk about the choices of plain vanilla litigation versus arbitration versus judicial reference, which is an alternative in California. Also, we're going to talk about mediation as well. Second, in California, liquidated damages used to be presumptively unenforceable. Now the legislature has changed the law to provide, within certain parameters, that parties can agree before a dispute arises as to the amount of damages caused by a breach of their contract. We'll talk about how to make them enforceable and any tweaks specific to real estate deals. Last, letters of intent, or LOIs, are commonly used by deal people, brokers, and their lawyers to reach a preliminary understanding as to the terms of a deal. But what is binding and what is not? And does it make sense and money to run the draft LOI by your lawyer? Foreshadowing here, typically, of course it is. As we go through our presentation, we'll note the takeaways for the next time you've got a deal to negotiate. Let's take a look first at ADR. We're going to look at traditional dispute resolution or litigation, venue and choice of law provisions, mediation, binding arbitration, and as I said before, judicial reference in California. First, let's briefly talk about venue selection and choice of law. You've seen them all the time in your documents that say all disputes must be filed in or presented in California, Delaware, wherever that might be, and all disputes must be decided under particular law, California, again, Illinois, or something to that effect. One point to consider that from the litigation standpoint is use the word shall. Whenever you use the word may, a court can use its discretion to determine whether it really wants to enforce that. And a very important thing that I've seen from my standpoint on litigation is make sure that the remedy provisions with respect to these things match both internally and externally. In other words, if there's a series of documents and you want it all to have California law apply and you want it all to be filed in Los Angeles, make sure all of those documents have that same type of provision. Otherwise, you're going to get a mix and match, and then again, a judge may not give you the result that you want. Again, why this is not a boilerplate is with respect to a war story that I can tell you that I had. In a very sophisticated document, unfortunately, the deal guys just cut and pasted a venue provision. It was supposed to be that any disputes must be filed in New York. Unfortunately, when they cut and pasted it, they only cut and pasted half of the provision, leaving the other part out. While I was successful, it took a lot to convince the judge that that's really what the parties intended. Let's look at mediation. First of all, people get confused a little bit about what mediation is. Mediation is usually non-binding. In other words, it's so that the parties can get together with an umbrella of secrecy to try to work out their problems without worrying that somehow something said in that mediation process can be used against them. Usually you have a third party, such as a retired judge or a lawyer, or sometimes if you're dealing with a particular type of area of expertise, someone like that, to work with the parties to try to get them to some result, which usually is, if it does work out, is usually that both sides are equally unhappy. One of the things from a contractual perspective that to keep in mind is the idea that because mediation is becoming more and more acceptable here, a lot of times there are forms that say you must mediate before you go on to either litigation or arbitration or reference, and if you don't, then you may lose some rights. And in California, those who have dealt with CAR forms, California Association of Realtor forms, you'll note that there's a mediation provision in there that basically says if you don't mediate before you go on to the next step of dispute resolution, you waive your right to assert a claim for attorney's fees later on, and California court has found that to be enforceable, so something to keep in mind. Now let's get into the process. In the old days, the idea was to have what I call the kumbaya session, where everyone gets into a room, all the parties look at each other, growl at each other, lawyers say why they're right, and which causes a whole bunch of angst and anger, which usually takes another 2 or 3 hours before people really get down to negotiating again. So most mediators now, except in limited situations, basically separate the parties into 2 separate rooms or 3, depending on the number of parties, so you don't have that situation. You usually submit a brief, which can be confidential or not, to the mediator, so the mediator has an understanding. And then basically, just like Henry Kissinger did to resolve the Vietnam War, what I call shuttle diplomacy, that's what the mediator does. He goes from room to room to try to convince both sides to get closer and closer together until there's a resolution or not. The plaintiff typically gives a summary to the mediator and is obviously the one who must at some point during the day give a first demand of what that plaintiff wants. The defendant gives a summary then to the mediator, and then the mediator picks and chooses information. It's all confidential, and then tries to get the parties to see the same. Oftentimes, an actual demand isn't even given for the first few hours. The mediator wants to feel out the parties, get all the parties recognizing what their strengths and weaknesses are, how much this is going to cost if they go forward. So for the lawyers out there, don't let your client get frustrated, because that's just, I think, the psychology of what all of these mediators have learned over the course of time. Now, sometimes when you're mediating, you can look for a creative solution, and I had one of those situations come up several years ago when I was representing a nightclub against some guy who claimed that he got beat up there. The client did not want to settle this matter, but I was able to convince the client to throw a few dollars towards the plaintiff, but in exchange, I got the plaintiff to agree to a permanent lifetime injunction preventing that person from ever coming anywhere near the nightclub. It seemed to be a good resolution for the client, and again, it's a recognition of the fact that you got to think creatively sometimes to get these matters resolved. Another question comes up, but what do I do in the meantime in terms of keeping a status quo? A lot of times the mediation provisions take some time to resolve, and so most mediation provisions, and in fact most law, still allows you to keep the status quo, and by that I mean to record a lis pendens against the property, to get an injunction, and perhaps even to get an attachment so that you don't have to worry about losing any rights. At the end of the whole process, if there is no resolution that is obtained, and by the way, if there is a resolution, get it written down at the mediation, get everybody signing on it, even if it's a one-pager that is unenforceable, that becomes enforceable, with the idea that the lawyers may make a much more complicated and formal agreement later on, but at least if that doesn't happen and they can't agree on all those terms, you've got the material terms agreed upon, and therefore you can go into court if it falls apart. So, but if you don't settle it, a lot of times what the mediator will do, the mediator, having seen the back and forth over the course of the half a day or the day, will come up with what's called a mediator's proposal. And in that, he or she basically tells both sides, I think that this is the amount that the plaintiff should receive, or whatever the deal points are. You have 24 hours to send me either a yes or a no. There's no negotiation. What's good about it is that neither side knows what the other side has said in terms of that mediator's proposal unless they both say yes. If they both say yes, you've got a deal. But if one says no, that one who says no doesn't know whether the other one said yes or no. So it keeps the bargaining position strong for both sides. Here's a question from one of you out there. Can you avoid delays under mediation? And sure, sometimes it gets out of control a little bit in terms of people's schedules, but a lot of times the provisions in the mediation contract or the clause say that the mediation shall take place within 30 days. One of the things to keep in mind, too, also with respect to this idea I said before about making sure that the mediation is complete before you go on to the next step, is to get the mediator at some point in time, if it all doesn't happen, to send an email to the party saying that he's deeming the mediation completed so that you can go on to the next step. And here's another question. What's the most important factor in successful mediations? My experience is that that's a good mediator, someone who knows his parties or her parties and are the business people. He's got or she's got some finesse and is convincing, obviously. You want to have that person be the objective one in the room for both sides so that both sides really listen and understand what that person is saying and don't think that somebody is swaying one way or the other. Of course, none of this matters if that either or both sides are just going through the motions because the court told them they must. If you're not reasonable and you don't look at these things from a business standpoint, then it's hard to settle these things. The old school strategy of the mediator bumping heads and yelling at everybody and telling them you're going to lose, just doesn't work today because most people are sophisticated enough not to get scared by that kind of stuff. Expense. That's another thing to take a look at. You know, sometimes you get what you pay for. If you go through all of the mediation and the mediators and you ask people, you know, who's good, who's not, typically you'll see the people who are more experienced and more successful tend to be a little bit more, but sometimes it's worth doing that. Then the other issue is with respect to do a half day, do a full day of mediation. And a lot of that depends on how complicated is the dispute and will that extra time educate the parties and move them towards resolution. So the takeaways from mediation are the mediator does not decide the case, that there's a cone of silence with respect to the mediation, so you don't have to worry about saying things and worry that the other side's going to use them against you. And then you got to, you know, can be concerned about how quickly can you get it done so that you can move on to the next method of dispute resolution, assuming you don't get it resolved. So this next one is a chart, and I'd suggest actually, if you're going to print out any part of this presentation, this is a good one to have in your drawer or on your computer somewhere because it really gives you a layout of the various alternatives and how they're good and bad. Because every deal and every contract, you should think about what is it that you want to accomplish, how and which of these provisions is really going to be helpful for you. So if you take a look at the first determination, is you get to determine who in effect the judge or the trier of fact is. In litigation, you don't. You know, everywhere you file a lawsuit, it's depending on which court and how they determine it, you just get a judge, and that's the person that you get. Sometimes if you find out the judge is you know, prejudiced towards you, you can bump that judge, but then you end up with another judge who, you know, and again, you have no control. Arbitration, you have some control. Arbitration, you can either, in your arbitration provision, determine both before there's a dispute, yeah, we want this person to be our arbitrator if there is a dispute, or you can use the arbitration provisions of JAMS or AAA where they have a provision where they'll send you a certain amount of potential arbitrators, and then again you get to cross them out and eventually come to a resolution. Same thing for judicial reference. You can either have that person determined ahead of time, or again through some process. And if you can't if you can't resolve it, then under arbitration, it's usually the arbitration service that has the process to determine the arbitrator. And in judicial reference, usually you have to go to the judge. Can you select the location? Yeah, most of the time. Litigation, you can. Most of the time, you have a venue provision that we talked about. If it's not reasonable under the circumstances, or if there's more than one place that a lawsuit could be filed, then it's not a sure thing. Arbitration, again, unless it's crazy unreasonable, usually you can pick where the venue is. The same thing with judicial reference, you can usually pick it. Discovery allowed. This is a real big issue because discovery is one of the most expensive parts of any dispute resolution, especially in litigation. It just seems never to end, and it seems very expensive. So what you can do with respect, sometimes with litigation, but certainly with arbitration and with judicial reference, is that you have a provision that basically says that both parties are allowed a certain amount of depositions, a certain amount of interrogatories and document requests, so you can limit it quite a bit. And so then you have the decision making in that situation is, are you the one that has all the information? And if you do, then you want to try to limit the discovery. And if you're the one that if there is a dispute, you're not going to have all that information that the other side has, you're going to want to broaden the discovery, and that therefore becomes a point for negotiation. Confidentiality, that's an important part for a lot of my clients, and the idea there is litigation, it becomes very difficult to have confidentiality. Yes, you can file or try to file things under seal, but the idea that the court system is set up to be a public forum, and therefore it becomes very difficult to keep things secret. That's not the same with respect to arbitration, because arbitration, a lot of times, even the AAA rules or the JAMS rules, they may provide for confidentiality, and certainly in your arbitration or provision, you may want to include a confidentiality provision. Judicial reference would be just like litigation, because in effect what judicial reference is the same thing as litigation. It gets filed in a court, but you get to, in effect, select your private judge to handle this matter, and so therefore you have that person's attention. It becomes more efficient. Stare decisis, you know, we can talk about that later, is that the idea of, is this, you know, decision, will it become something that you can use later on? Arbitration, it says no, but you can actually get to a point with the parties of having a res judicata scenario with respect to arbitration. Predictable results. You know, everyone thinks that arbitration, the arbitrator simply splits the baby. That's not necessarily true, especially when a lot of the arbitrators are retired judges who like to make decisions. Again, they're all maybe with respect to predictable results, depending on the judge, depending on the facts, and certainly depending on whether you have a jury. That becomes a little less predictable. Rules of evidence, if you're looking at things like that, then litigation, obviously you have the typical rules. Arbitration, the arbitrators are always very lenient and basically tell you they'll give it the weight they think it deserves, whatever that means. Judicial reference would be the same as litigation. Speed of resolution, typically litigation is the slowest and the appellate process is the slowest. Arbitration can be the fastest if you've got those provisions built in that talks about how long this is supposed to last. And judicial reference is faster, again, because you have someone focusing on your case with more time involved than a judge who's got other things going on during the day. Cost, litigation can potentially be the most expensive, and everyone has seen that happens, especially with respect to discovery and trial. It can be very, very expensive. Arbitration is potentially the least expensive in the sense of it being an expedited process, the sense of it being limited in terms of the discovery, that again, if everything is open-ended with respect to arbitration, yeah, you probably will save some time with respect to post-trial motions and appeals, but the process itself may be expensive as well. Judicial reference, again, is probably in between both of those. Jury, that's an important part. What's really good about arbitration and judicial reference is it gets around California's Supreme Court decision that says you can't waive a jury in a contract before the dispute arises. So in litigation, you're going to have a jury if the rules are followed, unless the parties agree sometimes after the litigation's filed to waive jury. But arbitration and judicial reference are kind of the sideways ways of getting a no jury resolution. And last, where it says right to appeal, this is an important thing to consider as well, in the sense that if you just want this over with, you go with arbitration because there's a limited way to attack an arbitration award and a very limited way to appeal such an award. But litigation and judicial reference have the same full-on rights of appeal. So if you think that this is an important issue, you don't want it over with, and you're worried about what's going to happen in the trial court or what's going to happen in an arbitration provision where you don't get an appeal, then stick with either litigation or judicial reference. So let's talk a little bit about arbitration. So when you are looking at arbitration, there are certain things to consider. First of all, do you want it binding or non-binding? There's a California process where you can have a non-binding arbitration. It's kind of your first shot to see how you're going to do. And then if it doesn't work out for you, you can then go and litigate it. If you're trying to save money and try to get this thing done, obviously you want to do binding, not non-binding. And then there's these provisions, and I've seen them in some lending deals, where one party can determine whether there's arbitration or litigation. So the provision would be something like, if the lender decides that it wants to arbitrate, this is the process that it goes through. Next, all disputes covered. I mean, this is one of those scenarios. Do you want everything? Do you want it broad? Or do you want to just carve out certain things? Do you want just appraisal issues arbitrated, or do you want any dispute among the parties covered by the arbitration? Potential parties covered. This is again, is it everybody? And there's a whole bunch of litigation going on in California about what's covered, what's not covered. Again, going back to the CAR form for residential real estate acquisitions and dispositions, the provision basically says that the brokers are not subject to the arbitration unless they decide they want to be. So it's just the buyer and seller. So you can make this as broad or as narrow as you want. A quick thing, number and selection of arbitrators. I've had arbitrations where there's a panel of three, where you have each party selects one and those two people select a neutral. If it's a big enough case, maybe you want that. For the most part, you're probably going to want just the one neutral arbitrator. It obviously is a lot less expensive. Arbitration service provider, again, there's a lot of them. California big ones are AAA and JAMS. And then those typically, do you want to incorporate those in your arbitration provision? So you say that the arbitration shall be determined under the arbitration rules or the commercial arbitration rules of AAA or JAMS. And then obviously before doing that, you should look at those rules to make sure they're okay with you. Specifying factors the arbitrator may consider, must consider, and again, that narrows what the arbitrator can look at. Is the arbitrator in a ground lease just looking at particular aspects of the fair market value as of a certain date and nothing more? You have that in there. Preliminary relief, that's what we talked about a little bit before. That's the idea that you can keep the status quo while you're going through the arbitration procedure. Discovery, again, we've talked about that before. A lot of it, little bit, somewhere in between. You got to have that taken care of in the arbitration provision so that there's no question later on. Remedies, what can the arbitrator determine? Is there a waiver of consequential damages, for example? Is there a waiver of punitive damages? What is the arbitrator allowed to do? Attorney's fees, of course, in most deals, there is an attorney's fees provision for the prevailing party. Location of hearing, again, that's that venue provision, which you also want to be similar, or to be identical to whatever other venue provisions you may have in the documents. And again, deadline for completion, you want to get this thing done. You don't want it being out there forever and ever. So the first secret word that we have that you should write down, I'm going back to my science fair days in junior high, and the word is solid. So if you wouldn't mind writing that down, that would be great. So let's look at the Adr takeaways. Again, it should be a case-by-case decision. This isn't boilerplate. You want to carve out certain things. The things that are really important if you're a landlord is you want to make sure that you don't have an arbitration provision for everything, because you want to carve out that summary proceeding in which you're allowed to basically go and evict a tenant, for example. In California, it's an unlawful detainer proceeding, but a lot of states have that same thing. If you have an all-over arbitration provision, that may block you from doing that. Lenders, similar situation. If you got the loan documents have an arbitration provision, make sure that you carve out that you have the right, for instance, in California, to go through non-judicial foreclosure, and that this arbitration doesn't block you from doing that. Again, look at creative approaches. Consider the limited scope of the arbitration provision. Consider extensive arbitration provision with agreed-upon details to limitation. Again, this is not a boilerplate decision, and it's not a boilerplate provision. Let's take a look at the next topic, liquidated damages. First of all, what are they? Second of all, are they generally enforceable in California? And then when aren't they? What are they? A liquidated damages provision is a provision in a contract that liquidates, which is a legalese for the parties agree upon the damages and the amount of damages if a party is in breach. So you still have to prove that there's a breach, but once that you prove the breach, then this provision says that the winning party gets X dollars, whatever that might be. A typical example of that is in, again, real estate sales documents where there's a deposit placed, and that if the buyer defaults, then that deposit becomes a liquidated damage and is paid to the seller by escrow. Are they generally enforceable in California? The answer now is yes. Civil Code 1671 provides, with some exceptions, that a provision in a contract liquidating the damages for the breach of the contract is valid unless the party seeking to invalidate the provision establishes that the provision was unreasonable under the circumstances existing at the time the contract was made. That's two interesting concepts. It has to be unreasonable, and it has to be unreasonable not when the parties are suing each other, but it has to be unreasonable when the contract was made. So what that says is that when the contract is made and not as appears in retrospect, therefore the amount of damages actually suffered may have no bearing on the validity of the liquidated damage provision, because the judge who's looking at this to determine if it's enforceable, or the arbitrator, is going to be looking when the parties were negotiating the agreement, not now when there's a dispute. Now, what does it mean to be unreasonable? And what typically that means is that the amount bears no reasonable relationship to the range of actual damages that the parties could have anticipated would flow from a breach. So if damages, if there were a breach, were somewhere between $100 and $200, and the parties as they're negotiating understand that, and yet there's a liquidated damage provision of $1 billion, that's not going to be found to be reasonable, and it's going to be considered a penalty and unenforceable. What the courts have said is that this is not, there's unfortunately not a bright line test with respect to the unreasonableness of this scenario, and essentially a factual question that the judge looks at every single time, unless there's something where the parties agree that that was actually a reasonable number, and then of course that's how it would go. So is there anything, any kind of a tweak or anything when you're dealing with the purchase or sale of real property? And California says, number one, you have to meet the requirements that we just talked about, and this provision basically says, and it's Civil Code 1675, is that if the real property liquidating the damages to the seller, it's enforceable if the buyer fails to complete the purchase, if it satisfies those obligations that we just talked about, those parameters, and by the way, then you have to have a few procedural requirements in the contract as well. And that the provision is separately signed or initialed by each party to the contract. And again, anyone who's seen, the CAR forms, that's a good example where you see that the parties initial that there's going to be this liquidated damage provision. But in all sorts of sophisticated agreements in California, when it has to do with purchase or sale of real property, again, you need to have those initials there. And if the provision is included in a printed contract, in other words, a pre-printed contract, it is set out either in at least 10-point bold type or in contrasting red print in at least 8-point bold type. And most transactional lawyers don't take a chance, and so when they're drafting these things, they still put them in bold type so that no creative person later on can try to undo it that way. One last thing to consider, and I've seen this is the idea of, is it only for damages? And yeah, the answer is this is liquidating the amount of damages. And so what creative people in negotiating and drafting documents have said is, well, yeah, but I want any remedy to be concluded by this provision. I don't want it to be that someone can then sue me for specific performance if it turns out that, that the damages aren't enough. So a lot of times what people do is they put it all under a big umbrella and they say any remedy, including specific performance, including damages, are covered by this liquidated damage provision. And if you have the negotiating leverage to put an additional provision that basically says that neither party shall have the right to assert a claim for specific performance with respect to this deal. So now let's turn to letters of intent, or LOIs. First, let's talk about the purposes of LOIs. Deals today are getting progressively more complicated. There are a lot of moving parts. Many deal makers use LOIs to see if the potential parties are in the same ballpark with respect to the financial terms. Why bother spending the money on lawyers documenting a deal if the parties don't even agree on the big picture terms like money, timing, and reps and warranties? Second, LOIs can help the parties put together a list of the material terms of a deal, again, to see whether they have covered all of the important elements of a deal and whether they each see eye to eye on those deal points. For a real estate purchase and sale, those points can include purchase price, what is being bought, timing of escrow closing, deposit, reps and warranties, due diligence, etc. And then following up from that second point, it might actually be easier and cost less in attorney's fees if the main deal points have been worked out before the lawyers get going on turning that 5-page LOI into that 2-foot-high pile of transactional documents that we see. As we go through the discussion today, keep in mind a question deal people often ask: should we use a lawyer to draft the LOI? Brokers like to sometimes ask you, why spend the money until you know there's a deal? There's obviously a weighing process that goes on. Spending on fees versus the mess you can get into if you don't have a lawyer draft or at least review the LOI before you sign. Let's go through some of the issues to help you make better decisions as to when to use a lawyer and when you may make the business decision not to. So what is, again, an LOI? The term is seen in real estate development documents, securities underwriting, and sales of corporate assets, among other areas. Generally, LOIs refer to a writing documenting the preliminary understanding of the parties who intend in the future to enter into a contract. The purpose and function of a preliminary letter of intent, sometimes people call it, by the way, an MOU, a Memorandum of Understanding, is not to bind the parties to their ultimate contractual objective. Instead, it is only to provide the initial framework from which the parties might later negotiate a final agreement if the deal works out. Calling a document a letter of intent sometimes implies, unless circumstances suggest otherwise, that the parties intended it to be a non-binding expression in contemplation of a future formal agreement, as opposed to it being a binding contract. But again, we're going to go through some of the landmines where you thought that it was not binding, but the agreement, or the LOI actually was found by a court to be enforceable. But regardless of the title, if the content shows that the parties intended to be bound and the other requisites of a contract have been satisfied, it may be a contract. We have to study the words in context to decide. So let's first look at a couple real-life examples. Sample number 1. In this case, which is the City of Vernon versus the Board of Harbor Commissioners, the language we had was the parties intend this statement to reflect the basic understanding between them, but agree that the transactions contemplated herein shall be subject to the execution of mutually acceptable, definitive, and final agreements to be negotiated, subject to the approval of the Board of Harbor Commissioners and by COSCO, which is the China Ocean Shipping Company. Here's the important part. This statement does not constitute a legally binding commitment. Now, in this decision, the Court of Appeal found that COSCO, who wanted it to be binding, could have no expectation of a binding contract. The statement of intent was just that and no more. The question, which is interesting, would be if you had just the first part that says we're going to have another agreement, would that be enough? And I think the answer is maybe. The idea is you want to really slam it shut by using that last statement that says it doesn't constitute a legally binding commitment. Another thing that's interesting to keep in mind are having provisions that say subject to the approval of a board or something like that. You can get into trouble with respect to that when you use those kind of provisions. You say to yourself, you know what, this might be a way for me to get out of the deal. The problem is that the courts have basically, at least in California, looked to see whether the board is reasonable in making that yes or no decision with respect to that consent. And you're putting your board at risk of having all of their depositions taken. Another war story, I had a settlement agreement that the other side wanted a provision that said this whole agreement is subject to the approval of the board of directors of a rather large company. The deal was signed, they had cold feet, they said the board has decided they don't want to take it. I basically then noticed up all members of the board of directors, had my colleague on a plane to, I think, Georgia, and while he was in the air, I got a call from the other side's lawyer saying, we decided we don't need all of the board members being deposed, so we will go forward with the settlement. So let's look at sample number 2. In sample number 2, the question was whether the parties' LOI created an enforceable contract such that the defendant, Marriott, was obligated to negotiate in good faith with a third-party financier. There was an LOI between the plaintiff and Marriott. Many terms still remain to be negotiated. As such, neither the letter nor the attached term sheet shall create the binding obligations among any parties in respect of the contemplated negotiations. And just a note again, when material terms are left for future negotiation, that weighs against the finding of the LOI being binding. The plaintiff, though, sought to find the investors to purchase several of these Marriott hotel properties. Discussions were held between one such prospective investor and Marriott, but they were unable to agree on the financial terms. Marriott abandoned its proposal for selling its hotel properties. The plaintiff conceded that the LOI didn't form a contract for the sale of the hotel portfolio because he never came up with a willing investor, but he said that there was an LOI that was binding by Marriott to make good faith efforts to negotiate with potential investors with an eye to consummating a sale. Later on, we're going to talk about a case called Copeland versus Baskin-Robbins as to whether there really is such an obligation to negotiate in good faith, but for purposes of this case, the court said that the LOI made very clear that there would be no binding agreement unless and until there was a definitive agreement signed by all parties. So that's good language. In no event shall any parties be bound unless and until the transactions described in the LOI have been made the subject of definitive agreements executed by all the parties. Again, this is another example. You want language that says there is no binding agreement unless and until the parties have executed a formal agreement. So let's look at the next example. This one was a one-pager. That's all it was. It was a term sheet that had basically one page. The final proposal was a one-page, 9-paragraph document regarding a ground lease for the property. After signing of this one-pager, the parties engaged in extensive but unsuccessful negotiations, but nothing happened. And no surprise, while they were doing this, the real estate market took a dive, and so one party wanted out. Here, what this case is saying is that even though it says the above terms are hereby accepted by the parties subject only to approval of the terms and conditions of a formal agreement, the court there said that wasn't enough to make it non-binding. The other problem was in the negotiating history. In the negotiating history, one draft or a few of the drafts had language that had that this was a non-binding clause. And unfortunately, in the final, that got dropped. So you get the non-binding clause provision dropped, and you got the court saying it's not enough to simply say that there needs to be a formal agreement later on. Again, there was no language that said this wasn't binding, and the court found that it was binding. Cautionary tale, obviously. All right, so now we have our secret word. Those who had done their science fair lab probably know what the next one will be after this one. This one is liquid. Please write it down, and we'll go on with the presentation. So here, courts may find your LOI is binding if. It says it right here. You include all the material terms, including reps and warranties. If all the material terms are in there, the court is going to, unless it has some very strong non-binding language in there, is going to look and balance it towards being binding. Alternatively, there have been cases that say if you agree that you're going to be bound by commercially reasonable and customary practices in determining something like reps and warranties and other covenants, that could also prove to be a situation where the court says, I can figure this out by looking at trade usage, and therefore I'm going to find this to be binding. And then obviously if you agree that your failure to achieve a more formal agreement will not limit enforceability of this LOI. You know, obviously you can make an LOI binding, again, assuming you want to do that. But here's a point to keep in mind, even with respect to materiality and trying to say that you don't have all of the terms. And that's with respect to real estate deals in California. So here we're talking for a case called Patel, and in that it was a specific performance of a real estate option contract. And the provision basically, as you can see, says that it was an LOI and almost all of the terms were agreed upon. What the court then said that equity does not require that all the terms and conditions of the proposed agreement be set forth in the contract. The usual and reasonable conditions of such a contract are, in the contemplation of the parties, a part of their agreement. In the absence of express conditions, custom determines incidental matters relating to the opening of an escrow, furnishing deeds, title insurance policies, prorating of taxes, and the like. So in effect, what the court is saying is that it can be a gap filler. It can go and fill in based on what is typical for the sale of real property and fill in the contract and find it to be enforceable. What the court did say in terms of material factors to be ascertained from the written contract in order to determine whether you've got all the material terms are the price to be paid, the time and manner of the payment, and the property to be transferred, describing it as it may be identified, obviously. So there are terms in terms of things that are material that you can weigh towards not having it binding, but be careful about the more minor terms. Even if they're not there, a court later on can come in and decide them against you and find that the whole thing is enforceable. So then I put together a pretty long list of phrases to support a finding of non-binding. So the first one, obviously, it says non-binding, not contractually or legally binding on the parties. That's short and sweet. The next one is that, when you get a little more colorful expression of the party's desire to negotiate the formal agreement in accordance with the terms and conditions set forth in the LOI. This is okay, but it could be ambiguous since it says the parties apparently agree to the terms and conditions, so probably stay away from this one. Next, subject to the party's due diligence, which each party may approve or disapprove in its sole and absolute discretion. Again, you see this kind of language a lot in the big due diligence provisions of real estate acquisition and disposition agreements. I like the sole and absolute discretion language, but the only out here is under the due diligence provision. It doesn't give you a broader way to get out of this thing. And again, you may end up with even though it says sole and absolute discretion, again, be careful about language. Don't have that you'll be reasonable, because if you get reasonable, then you end up like I told you about my war story, that you end up with board approval, something like that. Again, if you're reasonable, it becomes a question of fact, and you get more of a mess before you can get out of this thing. Last one on this page, notwithstanding anything to the contrary in this LOI, the parties expressly acknowledge and agree that the LOI does not include all the material terms, that's good, that would be included in the formal agreement, and thus does not constitute a contract for the transaction described in the LOI, that's good, but only expresses the interest of the parties to negotiate and attempt to agree upon a formal agreement. Again, this has good language that it doesn't constitute a contract, it doesn't have all the material terms. The potential downside, again, that we'll talk about a little later on, is it definitely looks like the parties have agreed to negotiate in good faith, perhaps, which is an alternative obligation they may have. Some more. Neither party shall rely on this LOI or any discussions regarding the transaction as a commitment, offer, or agreement of the other party. Again, good language that there's no reliance, which may help in the duty to negotiate aspect we'll talk about. Also helps in the attempt by the other side to say it somehow relied on your actions or your language, and that you should therefore be stopped from saying there's no deal. Next one, short and sweet. Except for paragraphs, whatever they are, which shall be binding on the parties, this LOI does not create any legally binding obligations on the parties at law or equity. Again, we'll talk about some of the provisions later on about that you may want to be binding, but this one is terrific in the sense of saying, look, nothing is binding here except for the few paragraphs that we've identified. Next, the LOI does not impose any enforceable obligations. For those who don't need to have 10 sentences saying the simple point, bottom line, nothing here is enforceable. Boom, you got it. Move on. Preliminary expression of general intent and to be used for general discussion purposes only. It is not an offer, acceptance, or a contract. It's a bit better. We're only using the LOI for general discussion purposes, and it isn't an offer, acceptance, or contract. By the way, you may want language about no offer in your formal agreement, because as you recall, as you're going back and forth with the drafts, you don't want the other side to say, see, these are all the terms and conditions, even though they weren't signed by the other side, because the other side sent it to me as a proposal. A lot of times what transaction lawyers do, which is a good idea, is throw a provision in the miscellaneous part of the deal docs that say, until the parties have signed this thing, this is not an offer. Last one, does not constitute any agreement, obligations, rights, or duties by either party to negotiate the formal agreement or to continue to further discuss or negotiate the formal agreement. No duty to negotiate, no duty to conclude a formal agreement. This has more protection, no agreement, no obligations, no duty to negotiate, no duty to continue to talk, no duty to conclude a formal agreement. This language is good. Last set. No implied covenant attached to this LOI, including any implied covenant of good faith and fair dealing to negotiate with each other. This plays into what I'll talk about in a little bit, the Baskin-Robbins case, that you don't want to end up somehow being accused of that there was a duty to negotiate in good faith, you didn't do that, and therefore I'm going to come after you anyway. This is not something that you want in and of itself. You want to tag this on to the no binding agreement provisions of your LOI. Next, the parties may negotiate with third parties, enter into agreements with third parties, and propose different terms than are in this LOI. You know, if this isn't an exclusive, then this is great language. Again, a lot of it depends on the leverage of your client at the moment. The parties may unilaterally terminate negotiations without liability. That's also good, to be able to say, look, I'm done, and I don't have any further obligations under this LOI, so that you don't have any open-ended agreement to continue to negotiate. Any party who relies on this LOI does so at its sole risk, cost, and expensive. Again, this is more no reliance language, which is helpful. You don't want to claim for estoppel against you, and you don't want the other side to say it spent thousands of dollars and let go of another potential deal because it relied on your actions. The practical thing to add in headings that say non-binding or prospective buyer seller. In the big documents, obviously in the miscellaneous, you have these provisions that say the headings don't mean anything, they're just for convenience. But in a short LOI, you don't have that kind of language. It couldn't hurt to throw in those kinds of titles and headings to make it very, very clear that this isn't binding. Now here's the trick, and here's a landmine. You have the best LOI in the world. It said non-binding, everything is terrific, but you do something wrong by your conduct. You look like you're actually moving forward with the agreement. That conduct can constitute enough to make that LOI enforceable. A case called California Food Services in 1982. The lessee entered into a letter of intent with a person who was to purchase the lessee's business and receive a sublease for the premise. Prior to the payment of the purchase price, the purchaser took possession of the premises and began operating the business. So before the actual payment occurred, the purchaser took possession of the premises and began operating. The court there said that an LOI can constitute a binding contract depending on the expectation of the parties, and the expectations may be inferred from the conduct of the parties and surrounding circumstances. The court said the fact that the party took possession and began to operate strongly suggests that both parties considers the terms of the letter of intent to be binding without the need of additional documentation. Again, this is something to keep in mind. Keep everything clean. When you've got an LOI, don't do anything that the other side may consider or at least argue that you consider this to be binding. You know, don't operate the business. Again, you can have provisions in the LOI if you need to do certain things to make sure that those actions that you're going to take cannot be constituting a conduct that allows the other side to say, ha, I've got this, you're now, it's now enforceable against you. Now, some of the terms of the LOI you may want to be enforceable, and we'll quickly go through these. I see the time is coming up. Confidentiality, an NDA, you may want that to obviously be enforceable after the LOI terminates and during the time of the LOI, so the other side doesn't get all of your confidential trade secrets and then can do something with that. In addition, a non-circumvention agreement. They can't use the deal information that you've given them, wait for the LOI to die, and then do the deal with somebody else. Exclusive negotiation agreement. Do you want to basically say, look, this is it. You can't go and negotiate with others. Again, leverage there. You got to negotiate in good faith. That, again, is something that we'll talk about in a second with respect to Baskin-Robbins. Other things, expenses, public disclosures, termination. You need the termination. You need to have that when that LOI is going to terminate and that the parties are done, except for those provisions that survive the LOI. Governing law, liquidated damages, sometimes those are in there that if the seller is taking this off the market to deal with you, is there a liquidated damage provision for that loss of opportunity? Indemnification, again, something that you would potentially look at in order to have it enforceable. All right, the last secret word, hopefully you all guessed that, is gas. And let's move on to the last aspect, which is this Baskin-Robbins case, the breach of a contract to negotiate in good faith. And here, Copeland, the plaintiff in the case, had an interest in buying the ice cream maker's plant, Baskin-Robbins, in Vernon. The parties negotiated, and the plaintiff, Copeland, made clear that his agreement to buy the plant was contingent on Baskin-Robbins' agreement to buy the ice cream he made there. Baskin-Robbins sent a letter which detailed the terms. Copeland signed and gave a deposit. The parties continued to negotiate, but nothing ended up coming to fruition with respect to the agreement. Baskin-Robbins then said, we're done with this. We have another strategic decisions that we're making, and this isn't within what we want to do. Copeland sued for breach of contract. Excuse me. He understood that there was no final agreement with respect to, to the deal, but he said, you breached the contract to negotiate this in good faith. The court there said there is, in general, a duty to negotiate in good faith, and that in this situation, that Baskin-Robbins may have breached that duty. So it's not an agreement to agree if, despite the good faith efforts, the parties fail to reach an ultimate agreement. In that scenario, if one of the parties basically just says, I'm done, and there was this duty to negotiate, then that's a breach. So at this point in time, the plaintiff, Copeland, is feeling good reading this opinion. He's thinking, great, I can go after Baskin-Robbins for this. But then they dropped it on him. What Copeland did is he basically decided that he wasn't going to go after Baskin-Robbins for his expenses during the negotiation, his attorney's fees and things like that. He dropped all those things. And that's exactly the type of damages that the court found was available for this breach of the implied covenant of failing to negotiate in good faith. It's not lost profits. Instead, it is the costs, the out-of-pocket costs that you may have incurred. So the plaintiff cannot recover for lost expectation profits because there's no way of knowing what the ultimate terms of the agreement would have been, or even if there would have been an ultimate agreement. So in that scenario, it's kind of what we call reliance damages. I relied on the good faith negotiations. I incurred consultant fees, testing fees, lawyer fees, things like that he probably could have gone after had he not dropped them out of his lawsuit. And so the court said, sorry, you're out of luck, and so you get nothing in this scenario. Again, one of the things to always keep in mind is the idea of the termination of the LOI. We talked about that there should be a provision in there. You want the survival most of the time of the binding provisions, the confidentiality, things like that. The NDA, non-circumvention may die. Obviously, you'd want it to die if you're the one seeking the deal from the other side once the LOI dies. And then, you have a provision that basically says if either have a specific date, it'll die, terminate 90 days after we sign this, or a particular date, June 22, and that you can even have a provision that says that the parties do not enter into the formal agreement prior to the expiration of the term, the LOI shall automatically terminate with no further actions of the parties. That's great. I like a specific date to be built in, though, as well. So the takeaways on the LOIs are, again, binding or not binding or somewhere in between. If you don't want it to be binding, use some good, careful language. If you want some of the provisions to be binding, make that clear, make that a carve-out for the non-binding part. Be careful about your conduct. Don't do anything that makes it look like you think the agreement is in play. And again, consider a lawyer at least before you sign, because once you sign, it's too late to make those tweaks that may have saved you from it being non-binding. I really appreciate everyone participating today. We have at Thomson Coburn a blog with respect to commercial real estate issues that's a little lighthearted involving California called The Ground Floor. That is the link up there. We'd appreciate you signing up, and we can continue to provide you information throughout the year. Again, thank you very much.